And we are joined today by some very talented individuals that are here to share a little bit of the background of our adoption process, our guardian ad litem process, and our multidisciplinary team process. And before we get into those particular issues, I just want to say that while I believe that our court has made some tremendous progress over the past year, obviously in terms of getting past what took place over the last couple of years, but also I think that we've made tremendous progress in rebuilding the relationship with the legislature and working with the legislature on some incredibly important issues for the future of our state and particularly for the future of our children. And I just want to thank the legislature for the opportunity to continue that dialogue, to continue working with the legislature. We had a very productive discussion in relation to House Bill 2010, the foster care bill over the past year, and also in relation to the creation of the family treatment courts, which 3 of those are already underway now. We're hoping to be able to expand that program as we move forward. But I just want to thank the legislature for allowing us to be a part of working cooperatively on those issues. And we had a discussion with Majority Leader Summers about adoption issues. And so over the past 6 or 7 months, we've been having discussions among a number of judges, sort of informally discussing how that process works and what we can do to improve that process. And are there issues that we need to bring to the legislature to have statutory changes that can help that process work more efficiently and work better for our children? So the first issue that we are here to discuss is our recommendations relating to the adoption process. And Judge Moats, who is Judge Alan Moats, who is a circuit judge in the 19th District, that's Taylor and Barber County, is going to share with you some of the recommendations that we have that are a part of that working group, a part of that discussion that we've had over the past 6 months. Secondly, we know that there have been a number of issues that have been raised to the court by members of the legislature about the guardian ad litem program, how that works, how it is overseen, what are the responsibilities and duties of guardians ad litem throughout our state, and who holds them accountable and how that process works. So we want to share that with you, and then I'll come back and share a little bit about some things that we are working on as a court to ensure additional accountability in that process. But Judge Carr Williams, who is also the head of our court improvement program, will be sharing that process, how that process works, and take any questions you may have about guardian ad litem and how the guardian ad litem program in our state. And then finally, we were asked to discuss with you how the multidisciplinary process works, multidisciplinary teams, how they are formed, what their role is, what their function is. So we will share all those issues with you and then take any questions you may have. But again, I want to thank you for the opportunity to work collaboratively with the legislature, with the executive, with the DHHR. We know that these issues that we're dealing with are incredibly important for our children, for our future, to ensure that they have safe, healthy, loving homes to go home to each day is all of our goal. And we have a tremendously talented group of judges throughout our state that work in the courtroom each and every day dealing with these issues. And they have, I think, a very helpful perspective of how we can improve this process and make it work better for our families and for our children. So I'm going to go ahead and turn over our presentation to Judge Moats to talk with you about some thoughts we have that we believe can make our adoption process work better. Judge Moats. Okay, thank you.
Mr. Chairman, ladies and gentlemen, thank you for allowing us to be here. First of all, I want to just give you a little overview of our adoption process. Majority Leaders Amy Summers, who happens to be up in my county, Taylor County, she and I have met frequently, and we met back in August to discuss this entire process. And we have worked closely with her under the guidance of Justice Armstead over the past several months, as Justice Armstead said in House Bill 2020. But to understand the proposals that we are making, I first want to explain a little bit about how the process works. And I've been doing this a long time. I'm finishing up my 23rd year on the bench. I was a prosecuting attorney for almost 20 years before that, so it seems like a long time. But the adoption process, and what we are talking mostly, is in the context of these abuse and neglect cases. And in looking at this, the abuse and neglect cases in our state have just literally exploded over about the past 6 or 7 years. I would average any place from 40 to 60 cases a year. Back about 2013, they just started going up drastically, up to 100, 200, 250, and they have not slowed down. And it's not that way just in my circuit, it's in every circuit across the state. I ran into our Supreme Court clerk, Edie Nash, before I came in here, and she said the court right now, today, is at 271 appeals in an abuse and neglect cases just this year. And that is a lot. So there's a tremendous amount of cases that presents a huge strain on our entire system at every level, from what you've heard. So the abuse and neglect cases, as they go through the process in the court system, have a lot of caseworkers from CPS, lots of attorneys involved, and a lot of judge time. There's a lot of facets to it. So when a child goes into a foster home, before there can be an adoption in the abuse and neglect case, of course, that's assuming that parental rights are terminated. And there are all kinds of time periods built in, including appeal rates. But after it's all said and done, if a parent's rights are terminated and a child is available for adoption, the child has to live in that home for at least 6 months before an adoption can be granted. And under the law, the adoption has to take place in the county where the foster parents and the child live. Now, when a petition for the adoption is filed, no matter what county it is, it's going to be, again, in the county where the parents and the child, the foster parents and the child live. Right now, under the law, the hearing cannot take place for at least 45 days after that petition is filed. Now, when I started as judge, that was not the case. There was no waiting period, and I think it came into being sometime right around 2001 or sometime thereabout, and I was never quite sure the rationale behind it. I don't know. But that is the law. So when we talked to Majority Leader Summers, she said, what can we do to try to maybe smooth the process out some and avoid some of the obstacles and perhaps to speed the process up? She said, hopefully without costing a bunch of money. And so what we came up with were 2 proposals. Number one, to do away with this 45-day waiting period, because we could see no good reason why it should remain in effect. As I said, the child has to be in the home for 6 months. If parental rights have already been finalized or terminated, and the DHHR has given consent for the adoption and all the requirements have been met, we don't understand the need to have to wait another 45 days. Now, the second proposal is in these cases, where abuse and neglect cases, to make it optional, to make it permissive, to allow the adoption to either take place where the foster parents live, or if they want to even speed up the process more, to allow it to take place in the county where the abuse and neglect case has been pending. And there are some rationale to that, because it can go faster. Right now, when an abuse and neglect case is pending and rates have been terminated, then the case is transferred to the DHHR adoption unit. And so the local worker has to prepare the file and send to the adoption unit, and sometimes that can take some time, perhaps weeks or even a month or longer. And then that adoption specialist goes through the process to make sure all the I's are dotted and the T's are crossed. And to have the adoption done in conjunction with the abuse and neglect case, that process can be speeded up quite a lot. The other thing is the workers who have handled that case know the case better than anybody. And we all know we have a tremendously high turnover of CPS workers. It is an incredibly demanding, trying, stressful position. Now, they tell me, and I meet with mine on a regular basis, I'll be meeting again with all of them Wednesday. They tell me that they deal with the cases, get to know and love these children and the families, but then the case gets sent off for somebody else and they don't get to see the happy ending. That they deal with all the difficult parts, they don't get to see the joy at the end, and that it is very upsetting to them. And if they could have the adoptions in conjunction with the cases that they've dealt with, that it would help them also personally, because it's a hard job. It's a grieving process they go through too, and it's heart-wrenching in a lot of cases. The adoptions we do, I know the ones that I do, I turn them into a celebration. Oftentimes, I have many people there. I tease some of them that who's watching Grafton or Philippi today, because so many people are in the courtroom. And I invite them to bring anybody they want, and we turn it into a celebration. Now, the caseworker doesn't get to be a part of that. The adoption specialist who comes in is the one who is there. In addition, once the case goes to another county for adoption, it's going in front of a judge who knew nothing about the case, who wasn't involved at all. And so if I have dealt with that case for 1 or 2 years, I know as much about it as anybody. And to have it sent to another court is difficult. Now, there are times when that needs to be. If I have cases where families are not able to travel long distances, or perhaps a child is disabled in some manner, or family or parents or whatever, it's not convenient. So we are proposing to make it permissive. So an adoption can either take place in the county where the abuse case was and speed up the process and help smooth out some of the obstacles, or if it's the foster parent's desire for whatever reason, then it could be done in their home county. So those are the suggestions that we have that could help the system without costing any money, at least anything that we apparently can see. And that would have to be done by statute. Then we are suggesting that the DHHR look at some of their internal policies to start doing some concurrent planning sooner than they do now. In other words, to start working towards the adoption approval process, even though the children or the child hasn't been there for 6 months. Now, sometimes that can be problematic if there is a disruption in that home, but overall, probably not. I mean, we need to do it so it can be done sooner. It's stressful for foster families to go through this. You heard our first speaker. It's incredibly stressful. I know. Both my children, I adopted. I know what the process was. I know even right up to the very end, I kept thinking in the back of my mind, is there something that can go wrong here? Thankfully, it didn't. So those concerns are valid. and they are typical concerns shared by most of the foster families that come before me. So those are the suggestions we have pertaining to the adoptions. Are there any questions?
Did you have any other presenters in the group? Okay.
All right, good afternoon. It's always probably a scary thing to see a judge lugging a couple big boring green books, so I apologize for that. But when Marissa was making her, missed you there, presentation, I had to grab a couple things from the code and the rules that I thought might be applicable. My name's Carter Williams. I'm a circuit judge in the 22nd Judicial Circuit, Delegate Rowan, Hampshire Hardy Pendleton. Had some bad weather this morning, so did you miss that? I want to talk first of all about just address something that, again, Marissa brought up about the foster parents while it's fresh in my mind, and I looked at the code on this. For a new judge, and I will say this, to follow Judge Moats is terribly hard. He's actually my mentor judge. Every new judge, I've been a judge almost 3 years, and what's the day, December 15 days, I've been a judge 3 years. Judge Moats was assigned as my mentor judge because I picked him, and he was good enough to do it. Because in all the years I was before him, and I think I counted the last time I stopped working for the Attorney General, I'd been in 30 circuit courts of the state. And he was always the one, Judge, you should know this, that I always aspired to be. If I always thought I would be a judge, I didn't think I'd be at that time, but he was always the one I aspired to model if I could. So, Judge, I mean that is an utmost compliment. But to deal with the JA cases, as you folks know, these are the most important cases, not only by my word, by your code, by the law that's been enacted by this body. JA cases take precedent on the court's docket, rightly so, because they deal with our greatest resource, our children. With that said, as a judge, I always tell my folks, I've never met a JA case, JA meaning juvenile abuse and neglect. I've never met a JA case that I felt I had too much information. I need as much information as possible. So the MDT is a great place for that information, and the GAL. We're going to talk about both of them here before we leave shortly. But to address one of the things that Marissa said about foster care parents, the two places that I think a judge needs to look most of all about what's going on with the child. What are they? Number one, who the child's living with. That's often foster parent or a relative when they're out of the home. We're talking about when they're removed. Secondly, where else do they spend their time? School. So personally, for me, I want the input of the foster care or the adoptive family or the pre-adopted family or the relatives. And I want the input of the school, because that child is going to be in those two places 95% of the time. So in my circuit, we encourage the treatment MDT. There's two types of MDTs. There are investigative MDT. It's chaired by the prosecuting attorney. It's supposed to meet monthly by code to look at cases that perhaps are parallel between criminal and abuse and neglect cases, primarily sexual abuse, physical abuse. We're talking about the treatment MDT here, the ones that occurs once a case is filed and is supposed to occur monthly with the proceeding. So the treatment MDT, and I'm looking right out of 49.405 paragraph B, says who is supposed to be on the treatment team. And it's supposed to consist of, there's 11 entries here. The DHHR's case manager chairs that MDT. Obviously, the parents attorneys, children or children's attorneys. But the third one listed is the child's parents, guardians, custodial relatives, foster, and adoptive parents. So for our circuit, the way that we want our foster parents involved is to make sure that they are invited and know the details of an MDT, not only when to come, but what the agenda is. So they understand when they come what's going to be discussed. That, to me, is the primary way that a foster parent is kept in the loop. And if that's not happening, Marissa, it should be happening, because straight out of code, they're a member of the MDT, straight up. So that's one way, and that sort of segues between the MDT process as well as guardian ad litem practice. As far as guardian ad litem, what are they? Sometimes I think folks might get a GAL, we abbreviate that. They are a licensed attorney. They have a dual role in these cases. One, they are a licensed attorney representing a child under 18. They also represent the best interest of the child. And as you might know, especially as children get older, those two are able to diverge somewhat. So we'll stick to the example somewhat of children of tender years, which would be children perhaps under 10, under 7. In my humble opinion, a GAL is the most important job that a licensed attorney could possibly have. And that is because you are representing and you become the voice of those that can't speak for themselves primarily. As children become teenagers and whatnot, I encourage those children to come to the MDT and have their own voice, have their own time on the agenda so they can speak. But we're talking about the ones that don't have a way to express themselves. And that's how important that job is for an attorney, appointed as a GAL. Rule 18A of the Rules of Procedure for JA cases says that all parties have the right to counsel. That means children have this right to counsel. GALs are to, when we come to the final hearing, we decide ultimately what's going to happen to a child and its placement after abuse and neglect has been found by a court. The GAL files a report and or makes a report to the court orally about that, required 5 days in advance of the final hearing, which is called the dispositional hearing. So the GAL has a tremendously profound job in these cases. The GALs that work in our circuit are resolutely independent. They are not beholding to any party, including DHHR. They are a primary cog in the MDT process. They are very much involved in the case planning process. They are additionally somewhat the court's eyes and ears in these cases. We meet with ours fairly regularly as the circuit judges. We oversee their practice. We oversee getting their orders in promptly. We oversee that they're required to be on a registry that requires them to have certain training. They are to have 8 hours of training, specialized training, every 2 years as GALs. They're also to have the general training for JA cases. When they're qualified, they go on to a registry. If they would fall out of good standing, they would be removed from that, and the court would not be able to appoint them. The training has to be approved by the Administrative Office of the Supreme Court. The training is derived and put on by the Court Improvement Project of the Supreme Court. The GALs obviously have to keep their CLE requirements in good standing with the state bar as well. There is an appendix in the rear of the abuse and neglect rules that is very specific on the job and responsibilities and duties of GALs. I'm not going to sit here and read that. It has basically 5 sections: the role of GALs, education and training, ethical considerations in their representation, duties during the initial stages of the representation, duties during the adjudicatory and dispositional phases. Adjudication is a fancy way to say trial. These are the trials before the court as to whether or not abuse and neglect occurred. If you find, you could parallel that with a trial in a criminal case to determine whether or not someone's guilty or not guilty. Dispositional phase, if abuse and neglect is found to have occurred, comes later, just like sentencing comes after a conviction. At the dispositional stage, the final stage is where the recommendation is made in writing by the GAL. And the GAL remains on the case until the child maintains permanency, which is of utmost importance because there's usually no one else left as far as attorneys other than perhaps the attorney for DHHR. The ultimate oversight, I think, to address maybe some of the concerns or questions in this body, frankly, is by the circuit judge. I think each circuit probably has a list of GALs they use and trust. We certainly do, and we rotate those according to our 3 counties, our needs. Our needs, obviously, in our practice wouldn't exactly parallel what they do here in this county because we don't have the same dynamics or demographics or services available to us. So GALs become even more important to rural counties such as ours where we need an independent voice and an independent set of eyes for to oversee the case. I'll give you an example. I had a case not long ago where I was told in a case that the child, there was still one dad left in a case. The child had been placed with a half-sibling, but this dad was still in the case, had done everything that was asked of him and more in an improvement period. And I was told that the 2-year-old, his 2-year-old, was not, or 3-year-old maybe, wasn't establishing a bond with him at visitation. And I said, well, I got that 2 times from the department and their contractor agency that was overseeing the visitation. I finally told the GAL in court, Madam GAL, would you please go and observe the visitation? So she did over the course of 2 or 3 weeks. And she came back to report to me that there was in fact a bond and the bond was growing and that dad is set to have his 3-year-old son returned to him after the first of the year. But for the GAL, don't know where the case would be going. So the GAL is a very important independent voice, presenting not only the child, but the best interest of the child, which can diverge, obviously, especially the older the child gets. Cindy, we want to talk about, as far as the GALs go, I think it'd be a good time to talk about the person that we're going to designate. You can do it. Okay.
You will speak to that.
Thank you, Judge. We wanted to take just a moment here because we have talked about the guardian ad litem system and sort of the oversight, as we said, is ultimately on the part of the circuit judge who was handling the abuse and neglect case. But also to keep in mind that these guardians are in fact attorneys and they are subject to the rules of discipline and the rules of professional responsibility that all attorneys are responsible for. And so there are various ways in which the guardians ad litem can be held accountable. We also, though, felt like that one thing that we have been hearing a lot from legislators, from parents, from various groups in the state, is that we're hearing stories about, well, the guardians are not meeting with the children. And of course, under the appendix that was discussed a moment ago, there is an obligation for them to meet with the child unless the court directs otherwise for some specific reason, that they're to meet with the children in person. And there are a number of different obligations and duties of the guardians that are set forth in the appendix. And so what we felt, we wanted to do a couple of things looking forward into 2020 about how we can possibly make this process work better from the court's perspective. And one of those is through the court improvement program that Judge Williams is the head of, is to look at seeing if we can distill the requirements that are included in this appendix into some basic expectations of guardians. That these are things that are sort of drilled into the guardian process. The guardians, as they go through the training, that they have specific expectations. And so we are going to work diligently through the CIP program over the next year to try to incorporate into the training that the guardians take more specific expectations that come from the rules that we've discussed. And those are things that I know we've heard a great deal from various individuals about. The second thing we're going to do is, and I'll let Cindy talk a little bit, this is Cindy Largent-Hill, who is the director of our children and juvenile services in the court system. Many of you are familiar with her and have worked with Cindy on a number of different issues. But I want to let her share another initiative that we're working on, and that is that while, again, we have very specific disciplinary processes to go through when a guardian does not do his or her job, we hope that we don't get to that point. We believe there are processes that we can put in place to ensure that we give the guidance along the way that perhaps a guardian needs to do the job as they're intended to do. And so we are going to designate a specific individual within the court system to be a contact for parents, for individuals who believe that the guardian that they have that's related to their case, their particular child, or the individual that is, they may not be the guardian for the child they've already adopted or in the process of adopting, but in an abuse and neglect case, we believe there should be someone that could be the contact with the court to let us know, and then in turn to let the circuit judge know that is handling that case if there are concerns about the job that the guardian is doing. So that person is going to be Stacy Mullins, who is the resource coordinator. And I'm going to let Cindy talk a little bit more about how that process will work, and then also to follow up with a discussion of the multidisciplinary teams. And then after that, we'll be happy to take any questions you have about any of these issues. But I want to let Cindy talk both about this contact person that we will have for guardians ad litem and also the multidisciplinary team. So.
Thank you, Justice. Good afternoon. Stacy is our resource coordinator, as Justice Armstead mentioned, and Stacy's job is to be out and about throughout West Virginia, working closely with circuit court judges and their assistants on a database we have for abuse and neglect called Janus. And that's what gives us lots of data and information we look at as far as timeliness to permanency and a variety of things. You might remember earlier at the beginning of this year's session, we spoke a bit about some of the data that was coming from the court related to foster care. So Stacy, in addition to that, she maintains the registry that we're responsible for. And so she communicates with the guardians ad litem. Once they've completed the course, they have to complete a document. They send that to her, she reviews it, and then she adds them to the registry, and she notifies the counties that they indicate that they would be willing to work in, and lets those circuit court judges know that the guardians is available in that area. So we're going to establish a log, and she will take those calls, field those concerns, put them in a log. She will immediately share that concern with me, and I will immediately turn around and reach out either to the chief circuit judge or the circuit judge in particular regarding the concerns that we've received. And so we're going to establish a mechanism to not only track that, but to log that, and we will have points in time designated to demonstrate that immediate response to the concerns that we receive. In addition to that, we are going to work very closely with the judges' work group, as Justice Armstead alluded to, on the training. I don't think anyone in here would deny that the foster care system is overwhelmed, overworked. It's busting at the seams. We have lots of infrastructure concerns throughout our state, whether that be from DHHR's perspective and the workforce and the training, but we have the same thing with guardians as well. When those numbers exploded, it affected every single person that walks into a courtroom for a juvenile-related case. So the guardians as well are taxed. Does not excuse them possibly not doing or fulfilling their responsibilities, but I do believe it's an indicator and a kind of another consequence of this overwhelmed system that we have. One of the things I think we can do, or that we're going to do, is we are going to take those rules of procedure and we're going to make them the crux of our training that we do with those guardians. We are responsible to do training with them every other year. That training is due in January of 2021. Justice Armstead and Chief Justice Walker have agreed that we can move that up into this coming calendar year because of the necessity and the concerns that have been shared, not only from Marissa's survey, but from talking with a number of you and your constituents. We've heard your concerns. We are looking to move our training up to the end of 2020 calendar year. In addition, we're going to try to make it a little more friendly, and we're going to have that training around the state. Guardians, attorneys who work as guardians ad litem typically are in private practice. They don't have an extra budget that might pay for travel, hotel, meals, all of those things. If we can organize it at a minimum, a north and south training, that might take some of the burden and might make it more attractive for the guardian to attend the training. So those are just a few things that we're looking to do in response to the concerns that we've heard and from Marissa's survey. With that, I will move over briefly just to speak about the multidisciplinary team. For all the reasons that make our common sense, the multidisciplinary team process is probably the most important piece of the system. That's the opportunity for anyone who knows anything about that child, those children, or that family to come together to talk, to share, to brainstorm, to figure out what that child and that family needs to move forward successfully. That's the key to really the case. Anyone that's involved with that child should be included in that process. The MDT process is outlined throughout state code. It's also referenced in our rules for procedure. Very specifically, it talks about requirements for the assessments. It talks about timeframes, confidentiality, access to information, those things that are critical. The Court Improvement Program has really embraced the importance of the multidisciplinary team process. Again, what we just spoke about, everybody is bursting at the seams. With more children in care, mean more multidisciplinary team meetings, means more folks coming together. We have made that a part of our training. We had a panel of all the different stakeholders at our cross trainings earlier in the spring. We were a part of the Handle with Care. We had a panel discussion with everyone that's outlined in state code. That discipline was represented in our panel with the Handle with Care. We have made that a priority within the Court Improvement Program. The second thing that we've done is we have what is we're calling our MDT project. And the MDT project is we're looking to see how the MDT affects the quality of the court hearing. So I have two staff that are working, Brenda Hoylman and Gabe Conley. They initially started with DHHR's 4 regional directors. They interviewed them and talked to them about the MDT process around the state. They've then subsequently talked to the community service managers. They've talked to CPS and youth service supervisors. They've talked to probation officers, and they're also talking with the Department of Education. All of those conversations have been face-to-face, or I should say ear-to-ear. They've been over the phone. They've not been a paper survey. Paper surveys are great, but sometimes just having that conversation over the phone, you can glean so much more information. So they have been organizing that information. This is kind of we're in that needs assessment phase. But we want to take that information, and then as I said, we have the Janus database. We're going to look at 20 counties, 10 who exceed the timeliness to permanency, and 10 counties who might be a little off as far as the timeframes are greater to permanency. Then we're going to look at the MDT processes in those 20 counties to see, is there a correlation between an active, robust MDT and timeliness to permanency? There may be, there may not. Common sense makes us think, yeah, there probably is, but the best way to see is to look at the data. So that's one project you may hear about that we'll be working with, but our goal is to reach out to every single discipline or person that's involved in the MDT process. So I think it's...
Okay, thank you. Delegate Wilson.
Thank you, Mr. Chairman. Thank you, ma'am, for being here. I really appreciate the information. So what is the process for correcting false information provided by a guardian ad litem and for holding them accountable? Thank you.
So the process for correcting false
information provided by a guardian ad litem and for holding them accountable.
I couldn't hear that last 3 or 4 words.
And for holding them accountable.
I would reference. We'll let the judge's response to that.
I guess maybe it would be nice to have a little context, but if you're saying that there was a misrepresentation in a court proceeding by GAL that resulted in what? The child going somewhere?
The result hasn't happened yet. But if a guardian ad litem showed up in court and gave a false report, what would you do about it?
Well, first of all, I'd have a hearing on it. Secondly, if I found that were the case, that guardian ad litem would be removed from my practice list.
Yes, sir. So how does the parent bring that to the judge's attention?
Parent has an attorney, so should ask for a hearing.
Okay, thank you, sir.
In my court, that would be, of course, all these proceedings are confidential, so that would remain.
Right. So the
closed
guardian ad
hearing.
litem goes alone with the child in the room, comes out, and then goes into the courtroom and states, the child said this. The child says, I said nothing like that. So the parent goes to the judge, and the judge says,
I appreciate the context, because in that case, then as the court, I would likely interview the child myself. With my court reporter, I would record that perhaps.
Yes, sir.
Without the GAL.
What if the judge were to say, that's the report I have, we're going to go with it, you have to deal with it? Is there a step beyond that?
I'm not sure. To me, that's got to be the court's oversight of that issue. If you're telling me the court accepted the GAL report, there has to be a record made on it. I think the court should have a hearing on it. Obviously, if somebody has an appeal right, if they believe that was misrepresented,
Yes, sir.
there's an appeal right. And to me, if there's a misrepresentation of what a child said, it could result in an ethical consideration.
Right. So if the judge does not take that step, is there a step beyond the judge?
Perhaps not in that particular case. There may be, as I said, that may be an ethical issue for the attorney.
Okay, so it's an ethical issue for the attorney. How do you deal with it as the parent?
Well, the parent needs to make the court aware of that. And
And
the court
the
has a
parent
hearing.
makes
The
the
court
court
has a
aware of
hearing on that, and if the court doesn't rule your way, then I think you have an appeal right. And then that's up to him. That's up to him and 4 others.
Okay.
That's
Thank you,
how I
sir.
would do it through the case.
So the very next step would be the Supreme Court.
Yes,
All
possibly.
right. Thank you, sir.
Senator from Jefferson.
Any other questions on the? Yes.
Yes, thank you. And thank you so much for coming and clarifying these issues. I can tell you that I have personally heard from many parents about guardians ad litems who never met with their child, and this is parents and foster parents. It doesn't seem to really matter, but it seems to be prevalent, and they have, some of them do not want to complain about it because that guardian ad litem has a lot of power over what happens to that child, and they do not want to have an adversarial relationship. So is there an anonymous
Well,
way?
it is an adversarial process. So every
I
party has an attorney. If I were the respondent's attorney, as I said to Delegate Wilson there, I would make my attorney aware of that. My attorney is to represent, if it's a parent's attorney, zealously represent the parent's position. Just as the guardian ad litem has their role to represent the child in the child's best interest. So it is a system where I would have the hearing. These are issues that the circuit judge and the circuit court should be overseeing. You swore an oath as a judge to be fair and unbiased and hear the case and decide the case on the facts that are found in the law that applies.
So,
Law that applies to JA cases is very well settled. So these are very much factual cases. That's why I said earlier, I've never met a case that said I had too much information in.
I understand. Is there no process for them to let the judge know anonymously? So that a foster parent
Are you
can
saying the parent?
let the foster parent let the circuit judge know the guardian ad litem never once met
You're
with
saying
the
a foster
child.
parent. So a foster parent is not represented by counsel.
That's right.
But if a foster parent had a concern in my courtroom, my foster parents and anyone, as I said, who has custody of a child, temporary or otherwise, is welcome to sit in my courtroom, invited to, for the hearings. Certainly a part of the MDT. And to me, the court should have the ability to hear from that foster parent if there are concerns and deal with those concerns. And if it meant the practice of a GAL that was problematic, I know what I would do in my circuit. I can't speak to others. They wouldn't be doing it anymore. Because if I couldn't trust them, that's gone. A GAL is an independent voice and has to represent the best interest of the child. So if they're not doing that, they have no business in a case.
Well,
I'm not sure what others would tell you today, but that's how I would do it.
I definitely appreciate that, and I'm grateful that you would let the foster parent have a voice, but that's no guarantee for those other judges who don't have the same policy. So what are we supposed to tell foster parents to do if they know that there's a guardian ad litem who is not meeting with the child?
Well, suppose they could write a letter or write something to the judge to make the judge aware of that, number one. That's the other process Judge Moats just reminded me of that Cindy just recited here, is if there is a problematic guardian ad litem in a circuit, we're going to have Stacey Mullins. Is it Mullen or Mullins? Mullins. Receive those complaints, keep a log of them, and let the judge know. So they'll have that information.
So will foster parents know to contact her? Is that going to be made available?
Yes.
Okay,
Yes.
that's fantastic. Thank you.
Yes.
And if you don't mind me asking, this review that you're going to be doing, is that going to, because you talked about meeting with the Department of Education face-to-face and with others. What about the foster parents or parents of adopted children? Are you giving them an opportunity to talk to you?
Absolutely. We've actually included Marissa on the panels that we've held for the trainings that we've done. She's an active member of our court improvement program. She's on the board as well as some of the other committees. She talks regularly with Brenda and Gabe, the two staff. And we're looking forward after the first of the year to sit down with her data and have her kind of walk her data through with my data person to look at that to see kind of how it can come together and where it diverges. So we see that as a resource. And we also see her alliance as a resource.
Okay, thank you. And do you have any idea of how long it will take you to do your survey and review?
So if you ask my data analysis person, she'll tell me you need a year. And I'm like, no, I don't want a year. So I honestly can't answer that because this is a brand new project that West Virginia has not done before. And we also have some free technical assistance who's working with us so that this might even could be published at some point, for the state. So it's not going to be a short process because you have so many disciplines involved, and there are different types of MDTs depending on how that juvenile or that child comes into the courtroom.
Okay, and I have one last question. I don't know who would be the best person to ask, but so we provide an attorney for the child and we provide an attorney for parents, but we do not provide an attorney for foster parents, even though some of these cases, the children have been with the foster parent for a year. Is there a reason for why we don't provide that?
Well, there are different categories. A foster parent, when they first start out, have a right, they always have a right in my court to come in and be heard. But we talked before about people who are recognized as intervening status, and that's after a period of time where they actually have a right to come in and not only be heard, but to call witnesses and question witnesses. Then under a statute we already have, after a period of 18 months, there is a presumption that the child should not be removed from that home unless there's an actual showing that it's in the child's best interest. So the longer the child is in the foster home, the more established the child becomes and the more rights are attached to that. Now, our Supreme Court has issued a series of decisions along those lines, stating that once a foster family attains intervener status, they have those additional statutory and due process rights to be heard and call witnesses. Up to that point, they have a right to come in and be heard and tell the judge what the concerns are, what the issues are. Now, as far as appointing attorneys, that would be something that if you all decided that you wanted to go that route, would cost take a lot of resources to do that. Our system right now is stretched pretty thin, and as you've heard, it's difficult throughout the entire process. I mean, in the best case world, everything would work according to plan. But when we don't operate in the best case world and we have more cases than was ever thought possible, it stretches every single facet of the system to the breaking point.
I do appreciate that. No, thank you. But you do say there's definite right for the foster parent to be heard in these court proceedings?
Correct.
No matter where they are in the state?
Correct.
That right is there?
Yes, and the Supreme Court has set that out very specifically through their opinions that a foster parent always has the right to be heard. Now, they don't have the right to call witnesses and cross-examine until they achieve that intervener status.
I understand that. And the oversight is the circuit judge. So if they don't feel like they did get a right to be heard, if there was something that they are unhappy about, they can write to the circuit judge and tell them.
Correct.
Okay. Thank you.
You're welcome.
Billy Gepak.
We'll just add one thing quickly to that. Judge Williams and I were discussing that there is some leeway within the code itself, and I know that some changes have been made. I think some were made in 2015, if I'm correct, and then some additional changes and some proposals that have been discussed by the legislature about allowing a judge to have discretion for appointment of counsel for a party that it believes in an action requires counsel in order for that child and for the rights of those parents and the child to be adequately protected. So there is some leeway in terms of appointment of counsel in the code as it is now. I know there have been additional discussions about increasing that discretion. So, okay.
Thank you, Mr. Chairman. I too have questions about guardians ad litem. I've had meetings across the 3 counties in my district and with foster parents and trying to address these issues. And the one question that I ask is, how many of you all have never had contact with your GAL at all? And hands shoot up. Without fail, at all meetings, this happens. I deal regularly with a lady from Monroe County, and her life has been devastated by the inaction or improper action, what seems to be, of the GAO in her case. But I heard during the presentation that the circuit judge has the direct supervision of the GALs, and that the GALs are required to do certain things. So given that this problem seems to be systemic across the state, I mean, I hear my colleagues from across the state talk about this very issue. It seems that either the GALs, or many of whom are being misleading toward the circuit judge, or the circuit judge is not doing what they need to do to make sure that the guardian ad litem performs up to the standard that's expected of them. So I'm wondering, what can we do to make sure going forward that more lives aren't devastated, and what can we do to make sure that they're actually going out to the home and visiting with the child in the foster home, rather than meeting at the courthouse 5 minutes before the hearing and having their meeting there?
Well, I think this is a good step, what Majority Leader Summers has put into play, and we've spent the last 5 or 6 months with a group of judges discussing these very matters and how we're going to address this. And I think the process that the Supreme Court's talking about putting in, have a contact person that the foster families know that they can contact if they say that this is not being done, and it's a problem if it's not being done. We need to know about it, and we as judges, we need to fix it. It's our responsibility. Okay. We need to fix it.
Finally, when can we expect these changes to be implemented through the court, and when can we expect them to filter down to the circuit court level so that these policies are enacted?
Well, I think Justice Armstead can answer that question.
Well, let me first start with, we have already designated Stacy as the person, so that is going to be with immediate effect, that we will have that contact for a person to be able to share their concerns, which in turn will then go to the circuit judge, so that they're aware that there are concerns that the guardian is at least, they believe the guardian is not doing what is expected, and then that'll have to be, addressed by the circuit judge. The ongoing process, we have sort of two groups. We have the CIP, which is Court Improvement Project, that Judge Williams is the chair of. We also have sort of an informal group that, of about 8 judges, 8 to 10 judges. We may add some to that I've been working with over the last 6 months, 8 months. We started out working with this group when we were asked for some input on the foster care bill. And then we were asked again by the majority leader to give some input on adoption. So this is an ad hoc sort of informal group that is trying to come up with recommendations. So I wish I could give you a definite time and date, but what I will commit to you is in a little over 2 weeks, I will be the Chief Justice. We will take these recommendations to the court and discuss how we would go about implementing reforms. I can tell you that we all understand and recognize the need for this reform. We understand the need to make this process work right. And we understand the fact that, we have guardians that come before the Supreme Court as well. They come to the hearings that we have. And so we have seen firsthand, not just the circuit judges, but we have seen the guardians come before the Supreme Court in appeals of these cases and recognize issues that are there as well. So I can't give you a date. I wish I could. I will tell you we will do it quickly. We understand the urgency of it, the need for it, and we will be working with the circuit judges, both of whom, two of whom are here. But we have a larger group of circuit judges that we've been talking informally with, saying, what can we do to make this process work better? And we will make sure that it happens as quickly as we can make it happen.
Thank you. I want to say I appreciate you all being here, and I appreciate you taking the time to meet with me offline. So I look forward to these changes that are coming. Thank you, Mr. Chairman.
Delegate Walker.
Thank you, Mr. Chairman. Thank you all for being here today. So I would like to know who's going to be responsible to ensure that the appropriate persons are going to be at the MDT meetings, for surely including the foster care and the kinship parents.
I didn't understand the question.
So the DHHR caseworker is responsible for convening the MDT, and so that person would be issuing the invitations, if you will, and notifying those that should be attending.
And so who's going to enforce if they do not do that? Who's going to be over it if they don't invite the appropriate persons?
So I don't want to speak for DHHR. If there's a systemic problem within their office, then that would be handled by them. Now, it is important, and the circuit court judges refer to the MDT when the parties prepare and speak in front of the judge to the cases. The MDT is referenced as well as the recommendations of the MDT at that point.
Yeah, and if I could add something to that, this is not a simple process. Just in my circuit alone, up until last year, I had over 400 active cases. Now, when you start talking about an MDT each month, how do you do that? In 400 different cases. In some of these cases, you have 6 or 8 lawyers involved, plus all these different sets of parents. And so that caseworker has to send out notices to these scores of people. Then you get constant conflict notices. We can't be there today. You talk about 6 or 8 lawyers practicing law in 5 or 6 or 8 counties. It is incredibly difficult. And so it comes again down to the resources being stretched so incredibly thin. The concept is wonderful, but when you try to put it in play, it would be like everybody in this room trying to be in every county every day. It cannot happen. And that's part of the problem that we are up against. There's no perfect answers because of the number of cases.
And I'll add to this, excuse me, I feel pretty spoiled, frankly, in my circuit because I just had a JAL. They not only go to the house and the school and the foster home, I just had one the other day go to Richmond, Virginia to see a child. I've had them go to the Carolinas. So that's what my guardians do. DHHR, my circuit, invites foster parents. So I guess it's a little foreign to me, and if I found out that was not happening, I can assure you in my circuit, it would be addressed. And I think that's up to the circuit judge to decide if he or she's going to take control or charge of that and fix those problems. Because it doesn't happen the places where I think that the judges are in control of that.
If I could just sort of circle back a little bit to Delegate Pack's question a moment ago about timing. One thing that I do think it is our goal to ensure, as Cindy has said, that when we're trying to move up the training and move it up to more, perhaps regionally, and we're discussing the frequency of training, the next time we would have that training, we would want this to be a part of that training. So if that helps in terms of the time frame we're looking at, we certainly want it to be urgent enough that it would be part of that training, and that when we talk to our guardians ad litem, that we emphasize these obligations. So, and also I think that this, as both the circuit judges have said, there is a large part of this oversight that comes from the circuit judge, and the circuit judge knows the circumstances, and they, I think, if I hate to speak for you, but you can pretty much tell when a guardian ad litem is or is not doing that job. I mean, I think that we can, even in the appellate aspect of it that I've been involved with in the last 15 months, we've seen sort of the range of, I would say, within the guardians ad litem that we've heard. And you can pretty much tell from asking those questions whether they have met, whether they have really got a sense of whether this child is making progress, whether this child is being cared for. So I think that that's, as we've said, and I hate to reemphasize it again, but it is a role of the circuit judge to a large degree. When there is systemic abuse of that, then there are certainly these guardians are in fact lawyers, subject to the same disciplinary processes that lawyers are if they don't do their job as an attorney and representing their clients. So there are other avenues there. But we want to try again, as we've said, to do what we can do to fix this problem without going to that extreme. If we can make sure that the training is correct and they know what those obligations are, and that we have an opportunity for people who do not believe they are fulfilling those obligations to come to Stacy and make that known, then hopefully we'll be able to address these in a much more efficient way and ensure that guardian is doing his or her job for that child.
Okay, well, unfortunately, we have run out of time, but we thank you all very much.
If I could just make one little correction to the handout. One, we did not go through every recommendation we made about the adoption. We made the major recommendations, but there was one that I think we talked about syncing up. It's supposed to be syncing up chapter 48 and chapter 49, not, I think it maybe said 29 in one location. It's chapters 48 and 49, making sure that that language is synced up. So I did want to clarify that and make sure if you looked at that and wondered why chapter 29 was in there, it's supposed to be 48 and 49. Yes. Is there anything else that we need to add quick? I know you guys. Well, thank you for the opportunity again, and look forward to working with you to address these issues as we move forward.
Okay, thank you all, and thank you to all our presenters today. Okay, in your packets to the members, you should have some coalition reports in there to take a look at, as well as draft interim legislation on foster care. And there's also committee bills for sponsorship for the House members at the desk. I recognize the co-chair for motion. Mr. Chairman, I move we adjourn. Co-chair moves we adjourn. All in favor, say aye. All opposed, same sign.